Thank you very much for coming. Thank you for the French Chamber of Commerce for welcoming us today. So we plan to do this introduction to the civil code 6 months ago, and because of the COVID, we postponed it. I'm not sure it's better today, but anyway, we have to do it. So we have many subjects to discuss today, so I will try to be quick on some of them and a little bit longer for some other subject. At the end, you can ask some questions. So if you have any question, you can keep it for the end of the presentation. So basically, don't look at the time. We'll speak about the Chinese Civil Code to have a general introduction about what is the Chinese Civil Code and what is a civil code. We'll see the multiple impact mainly on business, and we'll focus on the compliance and best practice. And at the end, you can ask a question, and I think after you can have a cocktail. So codification of Chinese civil law. What is a civil code and what is a civil law? So first, for the people who are not aware, you have different kind of a civil law system in the world. So you have the common law for England and US and Canada. You have civil law country. So you can see from the map that the civil law is the winner for the civil system. So what is the difference between civil law and common law? In common law, the judge can make the law. So you have the MP, the member of parliament, and you have the judge. Both of them can decide the law, can create the law. In a civil law country, only the MP can decide the law. Of course, it's not totally true. Sometimes the judge, if there is an empty space, will make the law. But at the end, the MP will prevail. So in the gray part you can see in the world, this is Muslim country, mostly Sharia. Okay, so in fact, you have 3 big systems, and you have also what we call a traditional law. But you can see China join the civil law country, which is a good news for European people because this is very similar principle to Europe. So a brand new code. What is a code? For the people who are here, I bring you 2 codes. I bring you the Chinese one and the French one. So you can see there is a big difference. We'll see why after, but the French one is the first one, so it's 1804, and the Chinese one was entered into force 1st January 2021. So that means this is the first, it's already 1 year you have a civil code. And I'm not sure how many of you use it in your daily life or with your business, but this is a very important step for China. So what is a civil code? The civil code, it's, let's say this is to unify all the civil law. So the main purpose of the civil code under Napoleon and in China is to unify the law for all the territory. And it's to make the law easy to understand for most of the citizens. So the principles of the civil code inside are very clear, very simple. Normally when you read it, even if you are not a lawyer or judge or a scholar, you can understand most of what is written inside. So you have general principle, you have general rules, and every citizen should be able to understand it. And the Chinese civil code reach this target. That means when you read it, it's easy to understand. What is very important also to understand is this is what we call a high-ranking applicability code, which means that if you have law before or after the civil code will prevail. So if the Chinese MP decide to change some law, and this law is against the civil code will prevail. So that means this is really like Lord of the Rings. This is a ring, and it will rule them all. Very important to understand. From a historic point of view, the Chinese civil code, the first attempt to do it was in 1949, and you have 4th attempt. All fail, and the 5th one was successful. So it's a long process. It's more than 50 years that the Chinese government is trying to push and to implement the civil code. And it was a huge, huge job to do it because, we'll see after, but because it repealed many, many laws. So civil code is a compilation of different law, contract law, tort law, succession law, wedding law, and they put it all together, they classify it, they make it logical, and then you have only one book. Or you say, okay, it's 1 year that the civil code was implemented, it's into force. What you need to understand from this scheme is it's not because you sign your contract before the civil code that the civil code will not apply to it. That means if you signed it 2 years ago and the contract is still into force today, in most of the time, for most of the provision of the contract, the civil code will apply. You have some exception, and you need to check which kind of terms in the contract will apply. But the exception is if to apply the civil code will create a big damage to one of the parties, then we'll apply the former law. If it's not creating a big damage to a party, then we apply the civil code. So it's not because in your contract you write contract law that the contract law apply. You have to apply the civil code in most of the part. You have to keep your question for the end, but we don't know what is big damage. So the judge will appreciate by himself, according to the situation and the fact, if it's the case or not. We don't have clear definition at the moment, but of course he has to be serious. So just to give you an idea of the civil code repealing existing law. So all this law today does not apply anymore. So the general principle, the succession law, the security law, real right law, so property law, wedding law, adoption law, contract law, tort law. All of them disappear already in 1 year. Tort law is when you create a damage and there is no contract, then you can sue somebody. It's a liability law. That means you want to sue somebody because he created damage to you. Okay. Security law, it's all what is mortgage, guarantee, such kind of things. So the civil code, you have 1,260 articles. For the French code, we have about 2,500 articles. So the first Chinese code, it's a little bit shorter than the French one, but still you have many change for all of this law. So we have new concept, we have major change, we have minor alteration. So general rules, 200 provision. Property law, you have 12 new articles. Contract law, very interesting, 70 new articles. So big change. Person, 43. Wedding, family, and so on. Tort liabilities, 8. So you have 246 articles which are totally or substantially changed. And we have 148 new articles of law. So that's why it will change many things for your personal life, for your business life also. And we'll see why after. So we'll mainly see property law, contract law, persons, and tort liabilities. So what are the general principles of the civil code? You need to keep that in mind. So you have special protection. And in all the articles of the civil code, you have many references for equity, fairness, good faith, for business relationship, for contract, for individual. Now, equity, fairness, good faith, it's our big principle, and you have many clauses to apply them. You have protection of society environment, gender equity, minor elderly protection, disabled people protection, pregnant woman protection. Consumer protection is very important in the civil code, and there is a big step for this. So what are the impact for your business, from business to private? The main impact will be for contract law. Many change for contract law. Conclusion of the contract. Before to conclude a contract in China, and like almost everywhere in the world, it was an offer and an acceptance. That means a company send an offer with fixed term to somebody, and in the offer, it's clear that this company will accept to be bound by this offer. And then the party who receives the offer accepts the offer, and in the acceptance, it's clear that they want to be bound by the offer. And then we have the contract. Today, according to the civil code, you have offer and acceptance, and they say or otherwise. So what does it mean, or otherwise? I will give you an example for electronic contract. If you implement a system, a website to sell your product, and you put your product, your offer on the website saying that I'm selling a car for this price, and if you buy it, you click and you order, then I accept to sell the car to you. From the moment the consumer go to the website and place the order, even if you are sleeping, then the contract is bound. That means you didn't receive the acceptance of the other party. You just register your acceptance in the system, and that's it. So this is otherwise. And we'll see there's other cases which are much more complicated for the otherwise. And we'll see some example after. Electronic contract. Before, you didn't get any clear provision on electronic contract. Now you have many articles on the civil code to say that electronic contracts are valid. So this is a good thing for internet. Of course, we have cases and we have decisions from the judge saying that this is valid, but now the civil code is very clear. Electronic contract is valid in China. Pre-contract, that's a big step also. So do you know what is a pre-contract? A pre-contract is a statement, is a sole undertaking, is a letter of intent. It could be a memorandum of understanding. This is pre-contract. So before, when you sign a pre-contract for purchase and sales of product, you get the chance, according to the law, you have a Supreme Court decision saying that according to the way you draft it, you can be sued for liabilities because you didn't follow the terms of the pre-contract. And then the other party can sue you and ask the performance of the pre-contract. Now, according to the new civil code, pre-contract obligation is for all the contract, the lease contract, loan contract, whatever you want. So when you sign letter of intent, MOU, any kind of undertaking you send to the other party, you have the risk, if you're not careful, to be sued for breach of the contract. So this one could be related to the first article I mentioned. For the otherwise, do you get a contract by offer or acceptance? You can have a contract also because of the pre-contract. So this is a big impact for merger and acquisition because when you sign a letter of intent or MOU, you may be obliged, it's not obliged, I mean, they will not force you to implement the merger or the acquisition, but they can sue you for liabilities because you didn't reach the final agreement. So you should really have a true intent to close the deal. You cannot decide to sign a letter of intent and to say, okay, we will organize negotiation with the other party to sign a contract. And at the end, you say, I don't want to sign the contract. You have to be very careful the way you are drafting this kind of document today. General terms, also a very important step for the civil code. And you will see there is also a big impact, big change. So before, when you have general terms and conditions, for example, on your website, you say, okay, if you buy my service or my product on my website, then you have to follow the general terms and conditions. But it could be also when you sell the commodity to B2B companies, you send general terms and conditions for payment, for delivery, such kind of things. Before, under the contract law, Article 39, you have an explanation obligation only for liabilities clause and mainly for consumers. Today, the civil code says that for any contract using general terms, you have explanation obligation for liabilities plus provision affecting the material interest of a party. I will give you two examples. Let's go back to the letter of intent. A letter of intent can be considered as a general terms. According to the article, general terms are referred to a clause formulated in advance by a party for the purpose of repetitive use, which has not been negotiated with the other party when concluding the contract. So that means when you draft a letter of intent, today, according to the Civil Code, this is a general terms. So that means if you don't mention to the other party, oh, be careful about this clause, this clause, this clause, and this clause impacts the liabilities of the other party or will impact its material interest, then this is not valid. We have two examples of that. We have a decision from a Chinese court, I think it was in Shanghai, saying that the fact that the other party didn't mention that the letter of intent was not binding affect the material interest of the other party. So that means they didn't mention this is not binding. It was clearly written. They say, okay, you have to be careful about that. They didn't do it, so the other party sues them, saying that you breach the negotiation. You didn't inform us about this clause. You didn't give us any explanation about this clause. Then you are liable to pay us damages. First example. So when you are doing negotiation and when you want to protect your negotiation, today you don't use letter of intent. You use memorandum of understanding, because a memorandum of understanding you will negotiate with the other party. So just keep in mind for negotiation, memorandum of understanding, not letter of intent. Other example, which is good for lawyers, there is another cases where a company sues the other company about the letter of intent, and they say that, no, not about the letter of intent, about general terms and conditions, and they say according to the general terms and conditions, the jurisdiction clause and the lawyer's fees payment by the losing party was material interest, was affecting the material interest of the party. Well, this was rejected by the tribunal. They consider this is not affecting the material interest. So when you are doing business B2B, business to business, my advice today is probably, if you can, if you don't have so many contracts to sign, it's better to stop using general terms and to integrate all of this in the contract you negotiate with the other party. Because this, you are sure, it cannot be challenged. If you go on Taobao, on Tmall, the general terms are already updated. That means you can, they will highlight the main part they think it could be a problem, and they will at the end tell you, oh, you can call us for any explanation. Okay, so this kind of websites are up to date. And if you are a B2C company, then you have to be very careful on the way you are drafting this, because any consumer can change it. And don't forget, it will apply for any kind of business, any kind of contract. There is no consumer professional, does not exist anymore. So when you draft the general terms, the Civil Code also mentions that you have to use a fairness principle to the other party. So it cannot be unbalanced drafting. You have to pay attention to ask the other party to pay attention to this clause. And if they ask you, you have to be able to give explanation. And very important also, general terms will be void in any cases if the clause inside cause physical injury to the other party or cause loss of property to the other party, intentionally or due to gross negligence. So if you have understanding a dispute about the general terms, and if you cannot decide the sense according to the negotiation you have with the other party, when you have more than two interpretations of the general terms, then according to the civil code, the judge will have to take the less favorable explanation to the party who drafted it. So that's why it's very tricky today to use general terms for business. And of course, if general terms are inconsistent with contract terms will prevail, but this is normal. Another article, Article 502 of the Civil Code. Very interesting, this one also. If you have a contract which, according to the Chinese law, has to be registered with an administration, even if you do not register it with the administration, the contract is still valid. So, for example, IP license contract, if you want to pay patent license fees abroad, you have to register this contract with a SAFE and with a patent administration. If you do not do it, if one of the parties does not cooperate with you, you can sue this party to get paid according to the liability clause. So it's not because there is no registration and for any reason that you cannot execute the contract. Before, if it was the case, you can only sue for compensation for expense and loss. Now you can sue for liability, so it's much more easier. Article 509, environmental protection. When you negotiate a contract and you draft a contract, you have this general provision saying that you have to take care to take into account the environment. Preservation of resource, no pollution or damage to the environment during performance of the contract. How it will work? This is a general principle, so it will be hard to see how they will implement it, and this is a big question. But at the end, we may consider that it could be possible to terminate a contract if you can prove that the other party is not complying with that. And we'll see some other environmental impact. We have some other article on the civil code which will impact the business for environment. Alternative obligation. So this is totally new. It didn't exist before, at least for Chinese lawyer. So alternative obligation is where when you have a contract with multiple option. So that means you sign a contract and you tell to the other party, okay, I can give you, for example, you want to build a manufacturing, and you ask a quotation to a party, and this party tell you, okay, you can choose option A, option B, option C. The other party has to give the choice in a reasonable time according to the contract. And if this party does not give for any reason any choice, then at the end, according to this new article, the other party can decide at the place of the co-contractant the choice. So that means if you are not doing your job as a client to choose, then after a reasonable period of time, the other party can say, okay, you don't give me the choice, this is a timeline, this is a choice I choose for you. And you will be obliged to follow this choice. And once you make the choice, if you do the choice, then you cannot change it. And when you make the choice, you have to be sure that the object of the choice, the purpose of the choice is still possible. So you cannot choose something you know it's not possible to implement. But once you choose it, you have to follow it. Alors, joint and several claim and obligation. So this is also a new provision. The good news for you is the civil code says that if you want to have a joint and several obligation between the parties, you have to get the contract or you have to get a provision of the law. Okay, so for business, so you have you can draft a new contract saying that okay you want to refurbish your manufacturing. You ask a company to manage the refurbishing of your manufacturing, and you ask the design company, and you ask the company who will do the decoration. You can mention in the contract that all this company will be liable, joint and severally liable to execute the contract. According to this new provision, if you don't mention the share of liabilities between all of these companies, they will share equal liability. So 3 companies, that means 33% of 33, each of them. But because they are joint and several liabilities, you will be able to claim to these companies, to one of them, the total amount, and after they can claim to the other one, for example. So you have to be very precise. Of course, if you draft precisely who will do what and what will be the liabilities of each of them, then of course we'll follow the contract. But if you don't mention, you just say this is joint and several liabilities, then we'll have to follow the article. Now the next one. Okay, so hardship. Hardship, what is it? Sometimes hardship is it's confused with a force majeure. So force majeure is some kind of hardship, but this is one of the possible hardship. So hardship is when you sign a contract and the condition of the contract change during the life of the contract, then you can renegotiate the contract based on the condition. So before, hardship exclude force majeure. That means you can only go to legal action. Today, it seems that we take into account the force majeure inside the hardship. And according to the civil code, when you have a hardship issue, hardship matter, then you have to negotiate with the other party. So that means when you are the condition of the contract change and it will have a serious impact on the other party, you have the duty to negotiate, to renegotiate the contract. And if you are not able to reach an agreement, then you can go to arbitration and tribunal. So this is the first time the civil code introduced commercial arbitration in the law. So not only legal action, but you can choose between arbitration and tribunal. And before, for force majeure, you have to prove that the contract was not able to be fulfilled. This condition disappears. So force majeure will be wider in the hardship one. That means it's not a matter of can you execute the contract even if it's delayed, but this is a matter of do the condition of the contract change enough to affect seriously another party. Article 563, open-ended contract. So before the civil code, you can terminate the contract whenever you want if it's open-ended, only for lease contract, employment contract, agency contract. Of course, you have some time, for example, for the labor contract, like 30 days notice. Today, you can terminate any open-ended contract with reasonable time and notice. So if you have a contract without any terms, you can terminate it whenever you want. You just have to give reasonable notice to the other party. What is reasonable notice? I guess we'll have to define it for each contract. For this contract, normally the terms of the contract, open-ended contract for this contract, in fact, this is not possible because in China you have 20 years. According to the law, you cannot have a lease contract over 20 years. And if you decide to do open-ended contract, then any party can terminate it. Not only the landlord, but it could be the lessor. So both of them can terminate it. Alors, shared liabilities harm. What is shared liabilities harm? This is where you have where both parties did not fulfill the contract. Then both of them are liable under the contract. But if only one party did not fulfill the contract and the other party did nothing to try to prevent the damage, then the other party will be liable for doing nothing according to the percentage she didn't do anything. So, for example, you know that you have to deliver, you have a purchase contract and you buy something and the other party will not provide you in time according to the delivery time, the product you need to produce your own product, and you have the possibility to buy this product somewhere else. If after the delivery time you do nothing, then you will be liable for additional loss. So this is why we call that shared liabilities. You have to be responsible and take any measure to try to limit your damage. If you do nothing, then the other party can say, okay, I will not compensate you the full amount. I will compensate you this amount, and you will have to keep another amount for what you didn't do. It's logical. We have that in France, in Europe. It's a common principle, and the Chinese Civil Code uses this principle today. Technology transfer and license contract. So we have new definition. We'll not go deep on this. New provision on technology licensing, patent licensing. Does not change so much the patent law, but it's important to know you have new provision and new definition. Entrustment contract. So entrustment is when you ask somebody to deal with a business or to deal with a task, then you have a new provision on entrustment. So before termination by death, loss of capacity, bankruptcy, unless you have an agreement or appropriate termination due to the nature of the entrusted affair. For example, you have to take care of a business and the terms of the business is over, then it will stop. And now for entrustment contract, you can terminate them at any time. And the compensation will be defined by the contract. And if it's not defined by the contract, then the civil code will take it over. Intermediary contract. So intermediary contract is when you ask somebody, when you have somebody in the middleman, and the middleman will bring you business and we introduce you to some other people. You have also new codification with this article for intermediary contract. So the middleman will report to the client the opportunity to conclude a contract or provide intermediary services for the conclusion of the contract. The good things for intermediary contract is there is a duty to disclose relevant information for the middle guy. And if he lied to you and he did not disclose the necessary information, then he cannot ask to be paid. So that means he has to be in good faith with you. So this is good because you have many intermediaries who are not very fair or they are trying to hide essential information. If you discover this guy is acting in bad faith, then you can decide to not pay him. But even if you cannot pay him, you still have to pay the required expense he spent for you to get the contract. After, we have what we call new typical contract. So, according to the contract law and let's say the contract history, you have the freedom of contract. That means you can decide to create whatever contract you want. And sometimes the law will define some specific contract, and you will have to follow for this contract the rules of the law of the civil code. So the sales contract is a typical contract. The loan contract could be a typical contract. The lease contract is a typical contract. So the civil code introduced new typical contracts. So we have the guarantee contract, we have the factoring contract, affacturage for French. We have property management and partnership. So, of course, this contract, this is not an invention of the civil code, but it just means that if you use this kind of contract in your business, now you have to check the civil code because there is no so much freedom for this contract. You have to follow the civil code. Of course, you have public order clause you have to follow, and after you have some freedom to decide what will happen. And if you do not draft this contract carefully and you don't deal with some matter related to this contract, then you will have to apply the civil code for the matter you didn't deal with in the contract. And after, we have what we call the quasi-contract. So quasi-contract is it's a new invention of the civil code in China, but it's a very worldwide use in Europe and other parts. So the first one is a gestio negotiorum. What is a gestio negotiorum? Very simple. When you have a factory and you have a neighborhood and you know there is a typhoon, and the typhoon is coming and the factory nearby is empty, the landlord do nothing, it's closed. And you are a very good neighborhood and you want to help and you want to ask the company will help you to protect the roof of your factory. You ask them also to protect the roof of the factory nearby because there is nobody to take care of that. You can do that because there is no contract according to this theory. And if you do it, you can go to see the landlord, your neighborhood, and to say, look, I spend how much money to prevent any damages to your factory. So you have to pay me back this money. So now, if you help somebody to prevent the damage, you can claim to get your expense paid back by this company or this person. But you have to be careful because the civil code say if there is a reasonable time for you to inform the other party, you have to inform this party before doing it. This is the first condition. And if after you did it, the other party accept what you did, then it will be considered as entrustment contract. So, and from the beginning. So that means you will have to report to the other party what you did and to give the invoice, everything, and you will be liable for what you did. Except if the other party, if you refuse to be under the entrustment, so you can refuse it. So this is the first theory. If you help somebody to protect him, then you can ask for the expense. Of course, you have to prove that you act in his best interest. After, we have unjust enrichment. So unjust enrichment is it was existing in the contract law, but the Chinese judge most of the time refused to use this unjust enrichment. What is it? Is you are a company and you send money to another company without any contract, without any reason. Your accounting guy did a mistake, he sends the money. According to unjust enrichment, you can go to see the judge and to claim back the money, saying there is no contract between us. And there is no reason why I should send this money to this third party. In China, judges are very reluctant to accept this kind of case because it was used a lot in the past for black investment. That means people did a black loan with huge money, and the guy never paid back the loan, and they don't have any contract. So many illegal money. They try to recover it with unjust enrichment. So when you go to see a judge in China and you try to apply for unjust enrichment, they are not very happy, and most of the time they will reject the case. So it was before the civil code. I hope the civil code will change it, but it should be the case. You have exceptions. That means if the other party receives the money and can prove that she really believes she will receive the money, it will receive the money, then this party can keep the money. So you say, oh, it's possible. I don't know if you are aware about a fake intentional fake order bank transfer, but in some cases, you have some company who came to see another company and they say, look, can you receive the money for me? And I will pay you 5%. And the other parties, this company was really believing they will receive money for a business transaction. So in this case, if you can prove that they were expecting to receive the money, they will be able to keep the money. The good things with unjust enrichment is if the party who receives the money sends the money to another party, you can still go to collect the money to the third party. Alors, we finish for the contract. So the next subject is personal rights. So you are all aware about cybersecurity, personal information law. As I mentioned from the beginning, don't forget the civil code. The civil code will prevail. So this is published after, but this is the main rules for personal information and privacy. So there is no big change according to what we saw for the people who study the personal information law and the cybersecurity. What is important to understand is, according to the civil code, the right of privacy prevails on the personal information protection. So that means really, first there is a privacy right for any individual, and after you have the personal information protection. So this will impact your business for your employees mainly, and for the personal data you will use or collect from third-party supplier client. So Article 1032 just defines the right of privacy. That means a natural person enjoys the right of privacy. So what does it mean, privacy, according to the civil code? Undisturbed private life of a natural person is private space, private activities, and private information that he does not want to be known to the others. So the question some scholars are asking today is, inside the company, do you have the right of privacy, for example, for the lunchtime, when you are at your desk and you are doing something? So this is something, probably we have some decision about that, or some implementation rules, but I think privacy will entering inside the company very fast. Definition of personal information, this is a normal definition. That means any information which allowed you to identify an individual. So there is no change according to what we know. And for the definition of and the principle and rules applicable to processing of personal information, this is basically what we know. You have to get the consent, you have to explain why you want to collect the information, the purpose of the use, how you will manage the personal information. Nothing very classical. Very important, Article 1010, you have sexual harassment defined by the Civil Code. So before the 1st January 2021, sexual harassment was not punished in China. today it's punished, but this is punished only under civil law. That means, for example, in France, if you do sexual harassment, you can get 2 years of jail. So this is criminal. In China, it's only civil. So you can sue somebody for sexual harassment to get money. So this is not the same. What is very good for the sexual harassment is now it will apply to equally to men or women. So a man can be sexually harassed. It will apply also to men. As a company, you have the duty to protect your employees from sexual harassment. So that means if you have a sexual harassment case, if you do nothing, the employee can sue you for sexual harassment as a company. So you really have the duty to protect your employees, to investigate, and to take measures to protect it. And when I say investigation, as I mentioned before, sexual harassment is not criminal. That means you cannot call the police to say there is sexual harassment. This is a civil case. You have to collect the information, collect the evidence, and if you think there is necessary evidence, then you have to take some measure to protect the employee. And if you do not do it, then the employee can sue you. And you will have to pay compensation. We got some case of compensation between 100 and 200,000 RMB. By the company and by the person. When you are suing for this, you have to sue everybody involved. Okay, so you sue the person who is involved, and you sue the company if the company did nothing. Alors, very important, we have a new article, Article 245 for requisition. So this is the article which allowed authorities to seize your property, to use them for epidemic control or prevention. So there is an article, and they have to compensate you, to give compensation to repair your damage. We don't have the definition of the compensation, but they have the right to do it, and you have the right to get compensated. So typically, hotel, or any other mask factory, such kind of things, the authorities can decide to seize what they want for the epidemic control. Tort liability. So we have the IP intentional infringement, Article 1185. You have a new base to sue any IP infringer for your IP. And the damages you can claim are much higher now under this new article. But of course, it has to be intentional. We have recourse for damage caused by employee. This is very good for companies. That means if an employee cause a damage to your company, you can sue this employee under the Chinese Civil Code. If you have a strike of employees and the strike is forbidden by your employee handbook, you can sue the employees under strike for the damage of your business. I think this is very good to protect the asset of the company. And there is another article I didn't mention. This is Article 1011, saying that if any person whose freedom is any person whose freedom of movement has been deprived or restricted by illegal detention or any other measure, then you can sue the person who keep you, for example, in your office. You cannot go out of your office. When you have a strike, employees most of the time will block the exit door. You can sue them also for this. If somebody keeps you locked somewhere, of course, you will have to prove it. So you need a camera and you need evidence, but you can sue this person for damages, for money. This is not criminal, but you can sue them for money. Useful for strike. After you have the recall of defective product. So the recall duty, after you put the product on the market, you discover that the product is defective, now you have a clear duty in the civil code to recall the product and to ask all the people or the company who buy the product to send back the product. And you will have to bear all the damages, all the costs linked to the recall of the product. So it could be the manufacturing, it could be the distributor, it could be the importer of the product, and all of them can be joint liability. So all of them will have to pay. And after we have environmental damage. So you can sue when you cause damage to environment, you can sue the company who caused the damage to ask this company to repair. This is a very clear principle. Before we got that for environmental law for land, manufacturing land, when it's polluted, you have the duty according to the law to do it. But now you have a general obligation to prevent, to protect the environment. And if you create any damage, then you will have to repair. So how to be compliant? First of all, of course, I think for a company, the most important is to review all your contract and to review your employee handbook and to see if your business is not impacted by the new clause, because, you know, as we see the general terms, today you think you are protected by general terms, and at the end, the other party can say, no, it does not apply. So you have to review all of them. The civil code is very simple to understand. So frankly speaking, my advice, if you're interested to learn law, is you can read 10 articles per day, and you will see it's very simple to understand all the articles. Of course, after it could be complex for some part, but it's very simple to do it. But the main issue will be contract and tort liabilities. You really have to review all your contract based on this. We'll have implementation clause because there is general principle and sometimes it's not so detailed. So we are waiting for some new regulation to explain, or some interpretation of the Supreme Court to explain what will happen for some case. So you need to check it carefully. You need to do due diligence based on the civil code. I mean, this is very simple. You take your contract, you check, okay, this is contract law, you know you are not up to date. Okay, so now all the contract you sign should be under civil code. If it's not the case, you know you have an issue. I don't know if you have any question. Yes?
Yeah. If you have some contracts that are drafted under the contracts law, you say we have a problem, but who have a problem and what kind of problem? The contract is still valid, right?
The contract is still valid, but this is, you think the clause will apply and maybe the clause you draft will not apply, for example, for the liabilities. If you have a contract saying, look, I will provide you this service, but I don't have any liabilities for if anything happens with the service I provide to you, this is illegal, you are liable, for example.
Okay, I just have another question. For the company handbook, is it considered as general terms or definitely not?
No. This is under labor law. Okay. So employee handbook, you need to review it under labor law for privacy or cybersecurity or personal information. It's not general terms.
Thanks.
Employee have done something, so can you sue him 5 years later, or have it been in
no,
1 year
no,
period?
No. If you sue in tort liability,
next week.
No, for tort liabilities, you have 2 years to sue. 2 years. It depends. For employees, we have a concern. We are not sure if we have to sue under labor commission or if we have to sue under the normal people's court. I think this is, you have, for labor relationship, you have labor commission. For civil law, you have people's court. So I think we'll apply the people's court. If it's people's court, we have about 2 years to do it. Yeah. Frankly speaking, my advice is don't wait to sue. You have to collect the evidence, and once you collect the evidence, you just sue.
Okay.
And to wait to sue after a long period of time, there is no purpose, because when you are suing the employees, to make an example, after 2 years, where is the example?
Yes, at the end you mentioned about return of goods or products in case of a defect or environment.
Yes.
Is it must be in the context of a signed contract, or for example, if it's a good someone gave to you as a sample or other and is defected, is it also impacted or not? For example, trade shows, etc. Sometimes you may give away.
If it's a good for me, it's not put on the market. There is this notion you have to put the goods on the market. That means there is a commercial relationship.
Just hold on. We received a question online. The person is asking, I guess it's more about the data management. So in the case that you're running a survey in China, are you allowed to export the data to another country, or is there any procedure? How do you deal with it?
It really depends on the data. If it's a normal survey asking only general questions, saying, are you happy in China? Do you like chou tofu or such kind of things? If we cannot identify the person, of course you can export. If it's personal information, when you have your mobile number, your email, and you say, look, so I'm living on this address GPS, then you cannot export.
So as soon as it's anonymous, it's all right?
No issue.
Okay. All right. Just a reminder for the people online, don't hesitate to ask on the chat as the person just did.
Who heard about the civil code, since 1 year? Nobody use it in his company? You did? Big change? How long it took to...
I'm a lawyer myself, so first of all, thanks a lot for the presentation. It wasn't easy and it was very clear. Actually, I have a question, if I may.
Yes.
And I'm from a civil law country as well, so we have a civil code. Italy, actually. And Italy, the civil code, what we learn at law school, is not a list of provisions of laws, but it's not a compilation of laws, but it's something else, something different. It's something that states principles which then apply to all the area of civil law. I just wanted to ask you if you have the feeling that there's the same purpose in the civil law, in the civil code in China, or it's just a compilation of laws that replace the previous laws?
My feeling is the same purpose.
Same purpose.
Yes, just not China. First, they use particular law, contract law, tort law, and so on. And at the opposite of us, I don't know for Italy, but for France, we just implement the civil code to replace many local law. So it was really an unification attempt of the French law to get only one law for all the territory. So China on this is a little bit different because they have already a big background, but they were not able to implement it for 50 years because it's a huge, you cannot imagine it's a small book, but to make it logical, to classify it, and to get something like this, it's a huge work. And I know they work with a German, I don't know for Italy, but French and so on. And yeah, it's more than 10 years for this one, they work on it. But for me, it will be the same. Maybe it will be harder for a Chinese practitioner because, for us, we get used when we start to learn law that we just check the civil code and we don't know what happened before. And for them, they have the practice to see the contract law and so on. So they will need time to change their mind. But after one generation, I think it will be the same.
Thank you.
Yes, I have another question about how it is applied today, because I remember at the beginning you mentioned that in the contract, for example, that was signed before, the judge may consider the impact. And
Yes.
The impact by applying the civil code is way greater and maybe unbearable for the parties. It may go back to the previous, I would say, law. So how is it today? Do we see a lot of people, for example, you mentioned, I have a factory, it's unoccupied, but I decided to restore the fence, so they go back to the previous?
I guess it will not happen because nobody is aware about this option. Okay, so you need time for the people to be aware about it and to learn. It's hard to answer this question. What you need to understand is this is not a major shift on the previous law. You have some change, you have big change in some part, but most of the time, this is what we know before. Okay, so it's not a big, we change everything and the law totally changed. No, this is not this. It changed, but most of it, it's a compilation of the past. So for the judge, we got the first decision, I think within the month it was implemented. So we have decision every day, but in China, the judge decision will not impact the other tribunal. So you don't have what we call a previous case. That means each tribunal is able to have his own thinking, and after it will be only when it go up to the Supreme Court, we'll have some kind of interpretation to say this is what you need to do according to the new civil code. So it's really, it will be a long run to see what will be the impact for all this matter.
Any question? This is probably not very relevant, but I know you were talking about civil law, but do you also cover labor law?
No. Labor law, you have special laws. They are not repealed, not cancelled. Okay. In Europe, we have also commercial code, we have criminal code, and when we saw that it took 50 years for China to have this civil code, I don't think we'll have a labor code. We have also labor code in Europe, It's not included. Labor code will be. It's really, you have the labor contract law, you have the labor law, it's still applying today. Okay. The impact on employees will be more about the privacy, about the tort liabilities.
Okay, thank you.
Cybersecurity law. It's still in place. Does not cyber security has nothing to do with civil law. Okay. But I think this is a good thing because you have official, if you check online, you type on Bing Chinese Civil Code, you have official translation in English. So it's easy to get access to it. You can read it. We have also a lot of change for private law. You have some funny cases. I don't know, a simple example is according to the new civil code, when you have kids born within the wedding and outside the wedding, they will have the same rights. And we have a famous case, I think, which popped up 1 month after the civil code came, where there was a famous tycoon who died, and he was a high-tech tycoon, so very rich, and the mistress sued the family to get 1/3 of the money because she has 1 kid and they have 2 kids. The result, she will win, but if you want to avoid it, then you need to make a will, because in China you can say, this kid will not get any money. I didn't check carefully the will civil code. Maybe it changed with the civil code, but normally it should be possible.
Do we have any further questions, or even online? Okay, seems like that. So thank you very much, Nicolas, for sharing tonight. Thank you as well, everyone, for joining. We'll show you the presentation, the replay link later. Once again, thanks to Nicolas and Costa Associate for presenting tonight, and we're looking forward to seeing you to future events. Thank you.
Thank you very much.